Good day, Crime Talk aficionados. Welcome to Crime Talk, your source for the latest developments in criminal justice and true crime. Today is August 6th, 2025, and we have a compelling lineup of stories. First, we examine whether Bryan Kohberger was creeping around prior to the Moscow massacre. Next, we investigate claims that Luigi Mangione is receiving some special treatment while in custody. We also discuss a former grand juror who heard evidence in the Karen Reed investigation and has now pled guilty to authorized disclosure of information. Additionally, Ghislaine Maxwell pushes back on the release of grand jury transcripts, asserting her position quite firmly. In another case, a convicted rapist argues for exoneration based on his claim of sexsomnia. We cover the arrest of an Oklahoma dangerous individual accused of slashing a woman's throat on a bus. And our legal quote of the day addresses criminals and their inadvertent self-incrimination. It's always the defendant's own words that get them, as I've said. And finally, our dumb criminal of the day features a man who robbed a Taco Bell by climbing through the drive-thru and, well, how it ended. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, go check us out on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com, sign up for a background subscription service today. When you do that, you're going to be able to get a plethora of information about the person that you are searching here in the United States. And you may say, why do I need to do this? Well, let's say somebody is coming into your life, or if you're not sure, you need to kick them out of your life because you think something maybe is just not right. So for example, let's say you do a background search and it comes up with all sorts of social media sites that, let's say your spouse or significant other is on and they haven't told you about. And then you find out there's a bunch of email addresses that they haven't told you about. Well, that's probably for those social media accounts, the dating accounts that they didn't tell you about either. And who knows, maybe you'll find that they have a burner phone as well. And of course, you're going to find out if there's a criminal history that they haven't told you about. I've actually seen it where spouses didn't know about what was going on with their spouse or significant other until the case was over. They just didn't tell them. Listen, go to crimetalksearch.com. Hopefully, I hope that there's nothing there, no surprises for you. But if it is, you need to know. Knowledge is power, ladies and gentlemen. Go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, one more thing before we get to today's docket. Let's talk about last night's live program that we did. Now, we put it out there. I think it was pretty straightforward. Bryan Kohberger is guilty. Convince me otherwise. All right? Convince me I'm wrong. We had our call-in number for 2 hours, ladies and gentlemen, for 2 hours. And I said, if you are a pro-Kohberger person, you get priority. Our system allows for 25 people in the queue. I think at most we had 4 at one point. And of course, everybody's in the comments like, oh, I'm the biggest pro-Kohberger person around. I just missed it. I didn't call in. Well, that one particular person, I said, hey, here's Frank's email address. Let me know. We'll set you up. We'll do a Zoom call and you can defend why you think that is innocent and he's been framed, right? So we didn't have any people call in. We had a lot of people call in that said, asking for a friend, I'm concerned about this. And I think we completely destroyed any argument that they said, oh, he couldn't have done it in the 20 minutes that he was in the house. How could he have stabbed somebody 52 times in that short amount of time? So we demonstrated, and I didn't even have the adrenaline going because I'm breaking into a house, killing multiple people. And we managed to do 52 stabs in 28 seconds, ladies and gentlemen. So any doubt that somebody had, well, I think it was completely dispelled. And, sometimes you have to demonstrate absurdity with absurdity, kind of like this little AI video that we have prepared. Probably do this on a more regular basis. Is this a pro-Kohberger person? Not sure. All right.
That video, you can't even prove it's Bryan's car. The whole thing is a setup. I'm a pro-burger.
But let's get to the docket. All right. So first on the docket, Bryan Kohberger, was he out creeping around? So newly disclosed records indicate that Bryan Kohberger, obviously now convicted in the University of Idaho murders, was previously looked at by police in connection with a comparable residential intrusion in Pullman, Washington, involving, coincidentally, female college students, approximately 1 year prior to the Idaho incident. Now, according to the documents released by the city of Pullman, law enforcement investigated a report from October 2021 in which an armed individual wearing a mask entered a residence occupied by 4 sorority members at approximately 3:30 a.m. The intruder, equipped with a knife, approached the bed of a 20-year-old resident who awoke during the event. Upon realizing the presence, the residents struck the intruder in the abdomen, prompting the individual to depart the premises without any verbal exchange. Now, the resident's roommates alerted police following the disturbance. This occurrence preceded by more than a year the November 2022 murder of the off-campus residents there in Moscow, Idaho, where Kohberger fatally stabbed 4 university students, specifically Madison Mogan, Kaylee Gonzalez, Xana Kernodle, and Ethan Chapin. Now, although initial inquiries in the Pullman case yielded no immediate resolutions, Kohberger emerged as a potential person of interest on January 10th, 2023, shortly after his apprehension for the Idaho crimes. Now, parallels between the events include the nocturnal timing, the use of a knife, the intruder's mask, and the targeting of a household of college students. A surviving witness in the Idaho case reported observing a masked figure, further aligning with the Pullman description. Well, the Pullman investigation took place 8 months before Kohberger enrolled in a criminology program at Washington State University, coinciding with the department event for prospective students. However, the inquiry was discontinued shortly thereafter when university records confirmed no attendance by Kohberger at such gatherings. Now, additional details for the records reveal that Kohberger's corresponded via email with the Pullman police chief regarding graduate research role there in his PhD program. And he participated in an interview in April of 2022 and expressed some great enthusiasm for those subsequent communications. Well, Kohberger is presently incarcerated in the maximum security facility, serving 4 consecutive life sentences following his guilty plea in the Idaho case. Let's talk about the Dateline interview that was done. All right. And it relates to the investigation as it relates to the leak of information. So there was the episode of NBC's Dateline program, which focused on Bryan Kohberger's case, obviously involving the Idaho murders, and it aired prior to the scheduled trial, and it continues to be the subject of a judicially mandated independent inquiry into potential breaches of confidentiality. Well, this investigation persists despite Kohberger's plea and subsequent imposition of the consecutive life sentences. So in June, as you may recall, the defense team submitted a request for this probe, prompting an immediate response from the prosecution as indicated in court filings. Both filings were sealed with and withheld from the public view following judicial guidance to examine possible infringements of court-imposed non-disclosure orders. Judge Hippler on the 4th Judicial District there during a May hearing expressed willingness to designate a special prosecutor with subpoena authority to conduct this investigation. Now, following the revocation of the non-disclosure order and Kohberger's sentence, lead prosecutor Bill Thompson and retired Moscow Police Chief James Fry affirmed the probe's continuation in discussion with the Idaho Statesman. Now, the 2-hour Dateline broadcast referenced individuals with direct knowledge of the inquiry and disclosed previously unreleased details, some accurate and others apparently inaccurate, according to a primary investigation involved in the matter. Both Thompson and Fry endorsed the efforts to identify and pursue legal action against those responsible for the unauthorized disclosure. Now, the inquiry remains active, independent of the concluded murder proceedings. Now, Thompson noted in this telephone interview with the Idaho Statesman that the process operates autonomously without involvement from the prosecutor, the defense counsel, or even Judge Hippler, and it maintains strict confidentiality as directed by the court. So the judge's prior observations suggested that the unauthorized information might have originated from either the prosecution or defense, potentially involving numerous specialists engaged by Kohberger's legal team. The program claimed that Kohberger's specifically intended to target Mogen, asserting that he initially proceeded to the third floor to confront Mogen and Gonsalves, though authorities have indicated uncertainty regarding a primary victim. Investigators believe one of the two may have been the intended focus, but lack any definitive confirmation, obviously because Bryan Kohberger hasn't said what his true intentions were or why he went there, other than to kill by his guilty pleas. Now, additional context was shaped by accounts from second floor resident Dylan Mortensen. A lead investigator described the reaction of those acquainted with Kohberger as one of profound surprise, emphasizing their complete unfamiliarity with him. So we'll see how this goes. And frankly, ladies and gentlemen, the investigation needs to continue. Obviously, I believe that information should be disclosed throughout these cases. It should be made public filing, and very, very limited information should be filed under seal in these particular cases. However, when there is a court order, they have to be followed, and your failure to follow them faces you in jeopardy of being held in contempt and the wrath of a district court judge. So it needs to be pursued. And if they can identify who actually released the information, that would be great. Now, what can the investigator do? Well, they can subpoena those communications, and then the producers and reporters at Dateline can either say, we're not going to turn that information over, our source, because of their level of confidentiality that they have as it relates to that, or they could turn over some sort of privilege log and say that this is protected by confidentiality under the source privilege. So we'll see where it ultimately goes. The information can try to be obtained. They may have seized phones. They're going to be tracking emails. Everything is traceable these days, unless, of course, somebody met in person in the middle of the woods, which, frankly, that's about the only way that you cannot be tracked these days, assuming you didn't take your phone with you. So we'll see how it goes. But whomever released that information probably needs to be charged with contempt and face the consequences of that. I find it highly unlikely it was the defense, but you never know. If there was somebody working in the office that had a little pillow talk with their spouse and they told the information to the reporters trying to get it out there, or more than likely, it was somebody in law enforcement. Maybe not necessarily somebody in law enforcement, but maybe the same type of thing. The spouse has a little conversation about what's going on in the investigation, and maybe they released it. Either way, could be trouble, because those police officers shouldn't have been having conversation about the pillow talk as it relates to the investigation. We'll see where it goes. Next on the docket, Luigi Mangione. Is he getting some special treatment because he gets a laptop? So obviously, Luigi Mangione, the man accused of assassinating United Healthcare CEO Bryan Thompson, has been authorized to utilize a laptop while detained in anticipation of his forthcoming trial. Now, Mangione will receive a laptop configured by federal authorities, available for his use 7 days a week between the hours of 8 a.m. and 4 p.m. And this device will lack internet connectivity or wireless capabilities and will contain only case-specific material, such as documents and videos supplied by the prosecution to the defense team. Now, on Monday, U.S. District Court Judge Margaret Garnett issued the order instructing the Metropolitan Detention Center in Brooklyn to facilitate the secure provision of this laptop. Now, Mangione's legal representatives asserted that such access is essential for the defendant to effectively ready himself for trial and participate in his defense strategy. So Mangione obviously faces the charges of the fatal shooting of Bryan Thompson, the 50-year-old parent of 2 children who the assassination took place outside a hotel in Manhattan during a professional event in December of 2024. Now, following a 5-day manhunt, law enforcement apprehended Mangione at a fast food restaurant, specifically McDonald's, in Altoona, Pennsylvania, where they recovered a red notebook containing entries that illuminate potential motivation for the alleged assassination. Now, the notebook includes deliberations on perceived shortcomings in the actions of Theodore Kaczynski, known as the Unabomber, during his activities from 1978 to 1995. An entry dated August 15th, 2024, approximately 4 months prior to the incident, expressing assurances in the planned course of action and deeming it appropriate and defensible. It further notes that delays in execution permitted additional research into United Healthcare, identifying the insurance sector as an ideal focus due to its alignment with certain criteria that he had. A subsequent notation from October 10th, 2024, indicates a timeline of 1.5 months remaining until the event, characterizing participants in the healthcare field as exploitive entities akin to organized crime figures. The entries also portray United Healthcare's December gathering as a significant opportunity that exemplifies broader deficiencies within the healthcare framework. Now, Mangione has submitted a plea of not guilty to all charges filed in both state and federal courts concerning the homicides, and should a conviction occur on the federal counts, prosecutors have indicated their intention to request capital punishment, the death penalty, ladies and gentlemen. So this issue comes up all the time, particularly in federal court, and particularly if there are protective orders. You have to either A, go review all the discovery individually with the client, or send a paralegal or an investigator so they can go through and review the thousands and thousands and thousands of pages that is becoming more and more frequent in every case. With digital technology, the media files are huge. It used to be if you had something that was like 1 terabyte, that was, oh my gosh, it's so huge, we can't imagine it. Now we get requests with all the video evidence that we have to submit hard drives to the district attorney's or United States Attorney's Office. We're talking 4 or 5 terabytes of information, which could be hundreds of thousands of pages and hours of video. And frankly, there's just not enough time to do it. A lot of facilities never used to allow what Mangione gets as his own computer. As you may remember, Sean Combs wanted access to his information, and the judge denied such a request. Normally, though, these laptops, if they're granted, are kept under scrutiny by the Bureau of Prisons from the United States Marshals. They're basically checked out, they're monitored. You can't do anything, but it saves the attorneys time and money if the defendant can actually go through his discovery on his own and help in his defense. Is it special treatment? A little bit. But in today's world, it's just common sense. Now, a lot of people in custody, they have tablets that they check in. They can download videos, movies. They can email from their little laptops that they have, no longer writing old letters. Now, that's also a bad thing as well for the defense, because guess what? You have no expectation of privacy in jail, and unless that's a letter to the attorney, there's no privilege. So when you're writing, mama at home saying, oh, I did bad things, guess what? The DA usually gets a copy of that as well. So I don't know. Luigi Mangione, presumption of innocence. We'll see where it goes. My guess is there's going to be a plea before we get to trial, but hey, we'll find out if I'm wrong. Next on the docket, let's talk about a Karen Reed grand juror who just pled guilty. That's right. A former grand juror in the criminal proceedings against Karen Reed has entered a guilty plea in her own legal case, acknowledging that she improperly disclosed confidential details from the sealed sessions. Now, Jessica Leslie attended a court hearing on August 4th, where she pled guilty to a single charge of criminal contempt. According to the court file, Leslie confessed to sharing sensitive information obtained during her service as a grand juror with persons not authorized to receive it. Now, though grand jurors have been explicitly instructed to maintain confidentiality regarding the proceedings, Leslie admitted to revealing the identities of multiple witnesses who testified along with the key elements of their statements. Now, the offense of criminal contempt may result in imprisonment and a monetary penalty of up to $250,000. However, there was a plea agreement in place, and Leslie received a sentence consisting of 1 day in custody, which was considered credit time served when she got arrested, and then 2 years of supervised probation and the required fee of $100 for a special assessment. Those feds always get it. Now, according to the available court documents and investigative details, the recipients were not publicly named in the filings, which consistently refers to them as unauthorized individuals. However, reporting indicates that Leslie shared the details, including witness names and testimony substance via text message with a close female friend who then posted related information on social media platforms such as X. This posting prompted an FBI investigation during which search warrants were executed on the cell phones of both Leslie and the friend, confirming the unauthorized exchanges. Additionally, accounts suggest the leaks may have extended to multiple acquaintances described as girlfriends, though no specific identities have been disclosed by any sort of verified source. Now, the disclosure occurred on various dates between August 11th of 2022 and March of 2024, encompassing information from multiple grand jury investigations, including but not limited to the Karen Reed case. And just as a little follow-up on the Karen Reed case, she has submitted a motion asking for the return of her vehicle, which she should get back. The case is over. There is going to be no appeal, so she should be able to get her property back. Now, obviously, if you followed this case at all, Karen Reed was cleared of the majority of the charges following 2 trials related to the death of her partner, Boston police officer John O'Keefe, with the initial trial resulting in a hung jury. But Miss Reed's legal issues are not over, as she is currently facing a civil claim for wrongful death initiated by Mr. O'Keefe's relatives. Let me just give you an example, ladies and gentlemen. Normally in the federal system, the attorneys cannot go in. If your client is a target, usually you assert Fifth Amendment protections unless you're given a grant of immunity. But either way, the client goes in without the benefit of counsel. In the state where I am in, if you have a client that's before the grand jury, you get to go sit in there, but you can't say anything. You don't get to ask any questions. You're just there if, maybe your client has an issue. That's fine. I still cannot disclose that I was in a room of, let's say 15 randomly selected people from the community who are there to decide charges. Can't discuss the contents of that. I could be held in contempt. Wouldn't do it. Let me give you an example. I had an associate. She was a great attorney. She did a lot of our civil work that we had. And she was selected and called one day for grand jury service in U.S. District Court. And I was like, okay, that's great. Well, how often does it meet? Is it 1 month? It was a 1-year term. So every month for, I think, 2 days per month, usually in the first of the month, they would go and meet and hear cases. And, I would, she goes, I can't talk about it. And she was very adamant. I said, if any of our clients' names come up, you may want to let them know to recuse yourself. And she says, oh, I understand. They know where I work, but I can't talk about it. I'm like, oh, okay. Anyway, but the point I'm making is she adhered to that oath. She never, not once. And even I could say I kind of, really, what? Any interesting cases coming down the pike? She's like, can't talk about it. I swore an oath. And that's what people are supposed to do, whether they're a grand jury or on a petite jury for a trial, whether it's a civil trial or a criminal trial. People need to follow their oaths. And this Miss Leslie obviously didn't. And it's probably the appropriate penalty for violating it. She's got to do probation, and now she's been through the legal process, and it's just not worth it. Just follow your oath. Next on the docket, Ghislaine Maxwell wants the grand jury transcripts kept secret, but I thought she was cooperating, right? So the attorneys for Ghislaine Maxwell, the former associate of Jeffrey Epstein, have expressed her desire to maintain the confidentiality of the grand jury records in the sex trafficking proceedings that resulted in her conviction and incarceration for 20 years. This position was articulated Tuesday amid ongoing efforts by the prosecution to persuade the court to disclose certain documents from the highly contentious matter, which is obviously involved into a significant political controversy. While Maxwell's legal team noted that she has not personally reviewed the materials given the inherent private nature of the grand jury deliberations. However, they argue against the public release of what they characterize as transcripts, potentially filled with unsubstantiated claims from testimony provided in closed sessions, absent an opportunity for her counsel to contest those statements. And in their submissions, her lawyer, David Marcus, and Melissa Madrigal asserted that notwithstanding public curiosity surrounding Epstein, such interest does not warrant a substantial breach of the grand jury confidentiality in this situation, particularly where the defendant remains living, retains active legal avenues, and continues to hold due process protections. Interesting. Obviously, the government says release it. The judge denied that request. Maxwell's position is, don't turn it over. But I guess you could say, well, we're just going along with the court's position because we already know that it was denied. But I think it's curious because, like I said, I thought she was cooperating. I don't know. Release it all, I say. Release it all. Next, a rapist who insisted his alleged sexsomnia should have absolved him of any wrongdoing. That's right. A convicted who sought to maintain that his crimes were perpetrated in a state of unconsciousness has now confronted the consequences of his action. Dean Fennell of Leicester, England, I'm sure I mispronounced that, was sentenced to 11 years and 8 months in prison on August 5th following his admission of physically, sexually, and emotionally abusing two former partners as detailed in a release from the Crown Prosecution's office. One can only imagine the relief the victims must have felt knowing that claims of sexsomnia, that convenient condition where sexual assaults are supposedly permissible because the perpetrator is ostensibly asleep, failed to sway the court in any way. Anyway, Fennell had previously entered guilty pleas to 2 counts of and controlling or coercive behavior. Prosecutors described how Fennell strangled and subsequently one of the women he was dating back in February of 2024 after she dared to question his domineering conduct. Naturally, because nothing says unconscious behavior quite like premeditated violence, followed by calculated assault. Anyway, Fennell habitually stole or concealed her phone or keys to limit her freedom, installed cameras throughout the residence to monitor her activities, inundated her with messages, and accused her of infidelity, according to the press release. And over the ensuing 2 nights, he compelled the victim into sexual acts while she remained paralyzed by fear of further aggression and domination. Yet, we are to believe this was all inadvertent, courtesy of his self-diagnosed sleep affliction. From the outset of the investigation, it became evident that Fennell aimed to dominate every facet of the victim's existence, stated the Detective Constable Caitlin Duggan of the Leicestershire Police. A profound observation, particularly when contrasted with the defense attempt to portray such dominance as merely somniatic mishaps. During police interviews, the victims noted that Fennell's eyes appeared closed during one, leading her to speculate he might have been asleep. Prosecutors anticipated that Fennell would leverage this to invoke sexsomnia, a contentious and infrequently validated sleep disorder wherein individuals purportedly engage in sexual acts without awareness. How reassuring it must be to think that such a diagnosis could render heinous acts inconsequential. Well, prosecutors dismissed that claim as baseless and successfully argued for its exclusion from the proceedings, enlisting a sleep disorder expert to refute it comprehensively. A report alleging non-insane automatism, yet it lacked any medical expert testimony, relying solely on the victim's observations because evidently anecdotal evidence suffices when attempts to normalize under the guise of slumber. Prosecutors further highlighted the absence of the diagnostic testing on Fennell, with their expert unable to endorse any standardized evaluation protocols. Moreover, prosecutors presented evidence that during one Fennell deliberately entered another room to retrieve a sex toy before resuming the assault, a sequence of purposeful actions utterly incompatible with sleepwalking unless one redefines consciousness to accommodate such absurd excuses. Shortly thereafter, Fennell submitted his guilty pleas as noted by prosecutors. His sentence encompasses additional convictions for assault, controlling and coercive behavior, non-fatal strangulation, and criminal damage against a former partner in Lancashire, per the press release. One might sarcastically applaud the justice system for recognizing that sexsomnia does not, in fact, grant impunity for systematic abuse. So Dean Finale has been unmasked as the violent, manipulative, and controlling figure that he is, and he now resides where he rightfully belongs, incapable of inflicting further harm on any women, according to the release. Now, beyond the custodial sentence, Finale has been subjected to a restraining order and sexual harm prevention order. Now, I wonder if Mr. Finale will be so accommodating if perhaps one night he is in his cell and the cell door opens and somebody does something rather violent to him, if he will consider that sexsomnia. I doubt it plays both ways. Next on the docket, a very bad man, allegedly. No, he did it, but it's allegedly him slicing a woman's throat on a bus in Tulsa. That's right. A 42-year-old individual has been charged with slashing the throat of a 43-year-old woman seated ahead of him on a public bus. So this all took place on August 3rd, and officers from the Tulsa Police Department arrived at a bus terminal following reports of a potential stabbing. Eyewitnesses informed the police that the suspect, identified as Robert Rhodes, had departed the area on foot, because nothing says I'm innocent like I'm getting the heck out of here. Anyway, patrol officers on bicycles pursued leads provided by witnesses, and they apprehended Rhodes without incident. Police noted visible bloodstains on his clothing and discovered a knife-bearing blood residue on his person as well. So, according to accounts from witnesses, including the bus operator, they indicated that Rhodes entered the bus and positioned himself immediately behind the victim with no evidence of any previous contact or communication between the two of them. The alleged attack occurred as the bus reached the primary terminal, after which Rhodes exited the scene. Now, given the nature of the victim's wounds, investigators from the homicide unit were summoned to examine the circumstances, and as of August 3rd, medical personnel reported that the victim had undergone surgical intervention and was in stable condition, with optimism expressed regarding her prospects for a full recovery. Well, Mr. Rhodes is facing allegations of assault involving a lethal weapon and impersonation under false pretenses, apparently given a false identity, and he is additionally detained pursuant to an outstanding warrant for evasion of justice issued in Missouri, which is failure to appear in court. So we'll give that young man the presumption of innocence, but yeah, not so good. Not so good. Not a whodunit, clearly. But I guess I would speculate, and I say it's speculation, that his attorneys will probably file a competency motion here shortly. All right, let's go ahead and get to this day in legal history. So August 6th, 1790, establishment of the Revenue Cutter Service. That's right, Congress authorized the creation of the Revenue Cutter Service, a precursor to the U.S. Coast Guard, to enforce federal tariffs and trade laws, including combating smuggling, a significant early federal crime. This laid the foundation for federal law enforcement against maritime criminal activities. Can you imagine people trying to get their products into the United States or the colonies at that time to avoid taxation? Can you imagine? On this date in 1890, the first federal execution under law. William Kemmler was executed in Auburn, New York via the electric chair, marking the first use of this method in the United States for a federal crime. The case raised some legal debate about the cruel and unusual punishment aspect under the Eighth Amendment. On this day in 1923, Chicago bootlegging raids hit Al Capone's early operation. That's right, federal agents raided speakeasies in Chicago, arresting 12 associates linked to Al Capone's emerging bootlegging empire under Johnny Torrio. The lesser-known action targeted Capone's early criminal network during Prohibition, foreshadowing his rise to being a crime boss. On this date in 1965, President Johnson signs into law the Voting Rights Act, enabling enforcement of actions, federal examination, and enabling the Justice Department to bring suits about voter denial. And our legal quote of the day, as I said, it has to do with, it's always the defendant's own words that get them. So, in the realm of legal stories highlighting the folly of certain offenders, a noteworthy quote is attributed to an anonymous mafia hitman during a trial in Sicily for double murder. Well, it serves as an illustration. Quote, "It was not me who killed those two men because that night I was shooting two other men." End quote. Obviously, the statement underscores the inadvertent self-incrimination that can occur when a defendant opens his mouth due to a lack of astuteness among some criminals of what is taking place. And finally, our dumb criminal of the day. Ladies and gentlemen, allow me to introduce you to the latest laureate in the illustrious Hall of Infamy, Key Warren, common spelling, Key Warren Lee Anderson, the undisputed champion of the Dumb Criminal of the Day Award. In a move that redefines the art of fast food folly, this 40-year-old mastermind allegedly scaled the drive-through window of an Ocala Taco Bell on July 8th, armed not with cunning gadgets or stealthy shadows, but with a large rock, because nothing says professional heist quite like channeling your inner caveman at midnight. So according to the police department, Anderson burst into the Taco Bell, brandishing his prehistoric weapon and demanding cash with all the subtlety of a bull in a burrito shop. When the employee wisely opted for self-preservation over serving up the register, he reportedly chased them out of the store, turning the late night shift into an impromptu track meet. But fear not, for justice arrived on four paws. The police department brought in their dog and it swiftly tackled our rock-wielding virtuoso to his ingenious hiding spot behind a dumpster, naturally. Well, take a look at this body camera footage, and it captures the poetic moment of apprehension, complete with Anderson sustaining minor injuries in his bid for freedom. He was promptly arrested on armed robbery charges, booked into the Marion County Jail on a $50,000 bond, and set to grace the courtroom on August 12th at 9 a.m. In the annals of criminal capers, Anderson's taco-tinged tango stands as a beacon of brilliance gone awry. Congratulations, sir. You have earned your chalupa of shame, the Dumb Criminal of the Day Award. And he cries like a little baby when that dog maybe bites him a little bit. All right, that's all we have for you today, ladies and gentlemen. Thanks for watching. We'll see you next time. And remember, the Constitution matters.